Transferring real estate licenses. A broker may never refuse a licensed affiliate request to leave a brokerage firm. They can't. If you just wake up tomorrow morning and you said, I'm tired of being with XYZ Realty, I'm going to go with ABC Realty where my friend is. And you reach out to your broker and say, hey, Miss Broker, I would like to, to change my brokerage to ABC Realty, where my friends are. That's going to be no problem. Your broker cannot refuse you. They will simply have to release your license to the new brokerage or back to the commission. Either qualifying broker or management party so designated by broker must sign release form and immediately notify real estate commission in writing of the transfer. Transferred license must be either forwarded to real estate commission or to the new broker with whom licensee plans to affiliate. Licensee shall have 1 month from time of transfer to affiliate with another broker or place license on inactive status. So if you're unsatisfied with your broker and you're like, I've had it, they're not training me, I don't know what to do, there's no support, whatever your reason is. And you said, I don't want my license affiliated with you anymore. And your broker, and you don't have a new broker in mind yet. I need to do my research and see what broker I want to go with next. Your broker will probably send your license to the commission. And the commission allows you 30 days, 1 month from that time that the broker sends them your license for you to get with another broker, or your license will be placed in inactive status. When transferring to a new broker, a licensee with any unfinished transactions under the former broker may finish and receive compensation for such transactions from the former broker, provided you can receive it, provided that both brokers agree in writing to the identified transactions. The former broker agrees in writing to assume full responsibilities for the licensee's activities in those transactions. The agreement expresses the terms of the compensation from those transactions. Okay, so that you can still be paid for your transactions, but all of those things must be in place. Transferring to another broker, a licensee whose license is released by a broker may not engage in real estate brokerage activity until WAL license has been delivered to new employing broker. Now, sometimes that can happen immediately. It's not like you're waiting months or days for your new license to be, released by one, transferred by the other. Remember, your existing broker has to release it immediately. And usually the new broker picks it up right away. Okay, but you can't transact any business until your license has been placed with the new broker. Broker affiliation. An active associate broker, salesperson, or CAM may not be licensed under more than one Georgia broker at the same time. I repeat, an active associate broker, salesperson, or CAM may not be licensed under more than one Georgia broker at the same time. Your license can only hang at one broker, okay? It can be released from that broker whenever you say and sent to the other broker, but it can only be with one broker at a time. It can't be with XYZ Realty and you're deciding to leave XYZ Realty and go to ABC and they both have it. It has to be released from one and picked up by the other. A person who holds a broker's license while acting as a qualified broker or firm may also hold an associate's broker's license and affiliate with a qualifying broker of another firm. I'll repeat that. A person who holds a broker's license while acting as a qualifying broker of a firm may also hold an associate's broker's license and affiliate with a qualifying broker of another firm. So, can a qualifying broker work with another firm? The answer would be yes. They would work with the other firm as an associate broker. A licensee may not undertake brokerage activity on any Georgia property except on behalf of an active broker with whom the licensee affiliates. So any transactions that you have, if you're working with a buyer that's looking for a home, you have a listing coming up, you're acting on behalf of the broker. All transactions belong to the broker that your license is hung with. A licensee may affiliate with a licensed broker in another state if that state's law permits it, and the Georgia resident licensee has a written permission of his or her broker. Inactive licensee. Licensees may go on inactive status by returning their license to the Real Estate Commission. And it's that simple, really, for an inactive license. If you decide that, I don't want to practice, and I see and hear it a lot. I'm tired, I'm exhausted, the market's bananas, I'm going to take a break. They will put their license status to inactive. And by turning it into the commission, that your broker simply sends it to the commission. An inactive licensee may not perform real estate brokerage activity on any real estate except on real property owned solely by the inactive licensee. So even though you're inactive and you want to sell your home, you will still be able to do so as an inactive licensee. An inactive licensee who wishes to be employed by an unlicensed person to perform brokerage activity for that person must first surrender their license to the Real Estate Commission and may not reinstate license without qualifying again as an original applicant, which means you have to start from scratch. You have to take the pre-license course, pass it, and then pass the state exam once your license is surrendered. A licensee may remain on inactive status indefinitely. Though license renewal fees must continue to be paid, a licensee may reactivate the inactive license only after completing the CE requirements if the license has been on inactive status. So even though you're on inactive status, you're still responsible for those fees to the commission, and you still must complete your CE hours if you decide to reactivate the license. Notification of legal action and change of address requires a licensee to notify the commission in writing within 10 days of the final disposition of any judicial court action whenever the case involves any offenses for which licensee has been cited. I'll repeat that because that's important. I know of a situation to where that didn't happen for someone, and the commission found out before they had a chance to tell it, which was not a good look. Requires a licensee to notify the commission in writing within 10 days. You have 10 days of your final disposition. So once you've been sentenced, basically, that's what a final disposition is, of any judicial court action whenever the case involves any offenses for which licensee has been cited. If convicted of criminal action, within 10 days, a copy of the indictment, accusation, and conviction must be provided to the commission. Licensee must notify Real Estate Commission within 1 month of any change in licensee's residence, mailing, or email address. And oh my Lord, this happens so much, I think agents forget to change their addresses or change their email address. I changed my email address recently. It just came to my mind, really quickly, like all of the places I need to change my email address. When I change my phone number, all of your information, you need to notify Greg. But what about your email address? Isn't that a way that your clients will reach you? That needs to be updated in the multiple listing services. So, do your best to notify the commission and your broker when there's any changes in your residential mailing or email address, and your phone number too. It won't hurt to notify, your broker of your new phone number. Okay, moving on to escrow account escrow and trust accounts. Requirements, maintenance, and disbursals. a broker who accepts cash, checks, or other items of value belonging to others, down payments, earnest money, deposits, security deposits, rents, association fees, or other trust funds in a real estate transaction, or whose affiliated licensees accept such funds, must maintain a separate, federally insured trust or escrow account at a financial institution in Georgia. So whenever you're handling funds, remember fiduciary responsibility, accounting. Whenever you're handling funds related to any real estate business, those escrow accounts are required. The account must be designated by the holding financial institution as a trust or escrow account. The account is not subject to attachments or garnishments. Brokers who do not accept trust funds are not required to maintain an account. However, if the broker at some point receives trust funds, the broker must open a trust account within 1 business day of receipt of the trust. So if your broker does not do business with trust funds, they're not required to get a trust account. Everything else can go into an escrow account. A broker may maintain the broker's own funds in a designated trust account only when they are clearly identified as the broker's deposit, and only to maintain a specific minimum balance or pay any service charges required by the financial institution. So a broker can designate a trust account for their own funds. Okay, and it usually covers miscellaneous things like, if your bank has a minimum for those sorts of accounts. That's a good example of it. Each broker maintaining a trust account must notify the commission of the name of the bank and the number of the trust account within 30 days of its inception. So the moment the broker decides to start handling trusts, they open the trust account, they have to notify the commission within 30 days. Minimally, on a monthly basis, the broker must reconcile the trust account with the bank statement. The reconciliation report must contain an explanation of any differences found in this balancing process, as well as any corrective actions. So that you have to say what's going in, what's coming out, and make sure it balances. A sales affiliate who has written permission from broker to operate a trust account must comply with all regulations related to trust account, as well as providing the broker on a quarterly basis a reconciliation report. So if you as a sales associate operate a trust account, you must still reconcile the trust account, which is a part of the regulations per GREC, okay? And then you must provide that reconciliation to your broker every month. Well, it says quarterly, but I have one, and I just send it to my broker every month. That helps me. It just shoots from a software that I have. Trust account examination. With reasonable care, the commission may examine a brokerage firm's or a licensee affiliate's trust account at any time. No notice. Commission doesn't need to give you a notice. They can examine those trust accounts at any time. The commission is authorized to examine a broker's designated trust account during each 4-year renewal period. And remember what the broker's designated trust account covers: miscellaneous stuff like service charges, you meeting the monthly minimum for the account, and so on. Brokerage firms are required to maintain either a manual or electronic accounting system, which must be in an understandable format and be reasonably available for inspection by representatives of the commission. And a lot of brokers use QuickBooks because you can just load so much in QuickBooks and pull a quick report. That's, one of the easier ones that comes to mind for me. A broker who disburses trust funds contrary to the terms of a real estate contract is considered incompetent by the Commission. Disbursal of trust funds. A broker must not disburse trust account funds until broker knows that the financial institution has credited the funds to the broker's trust account. Substantive regulations. A broker may only disburse funds from a trust account under the following circumstances: upon rejection of an offer, upon withdrawal of an offer not yet accepted, upon a reasonable interpretation of the contract so directed by the contract to the broker holding the trust funds. Circumstances for such disbursal involve disputes between contractual parties as to who should receive earnest money when contract is in default. The broker must notify all parties of the disbursal disputes. So, and earnest money is a big dispute. When who gets the earnest money, if the buyer gets to keep the earnest money, if the seller gets the earnest money, that's one of the biggest disputes when it comes to this. Upon a written signed agreement by all contractual parties with an interest in the trust funds, at the closing of the transaction, upon filing an interpleader action in a court and receiving a court order indicating instructions for a trust fund dispersal. So all of these things would be reason for trust fund dispersals. Usually requires written action, some sort of written action. Also, a broker who claims any part of the earnest money as part or all of the broker's commission or fee as verified in the transaction closing statement will have complied with the license law only if the transactional sale has closed. All funds of trust must be paid by check or credited at the closing or transaction. It's also paid via electronic transfers or ACH transactions. Abandoned trust funds. If circumstances infer that trust funds have been abandoned, a broker licensee may distribute these funds if the licensee has complied with the requirements set forth in the Disposition of Unclaimed Property Act. Brokerage advertising, inclusive of print, photographic, computer, broadcast media, applicable to property signs, billboards, newsletters, business cards, and the internet. And by the internet, I would think, now we're advertising on social media, we're advertising on Google, and Google Maps, Bing, all sorts of places now we're advertising. Advertising by affiliated licensees. All ads must be done in the name of the brokerage firm as it is registered with the commission. I'll read that again because that is so important, because I see it all too often that is not the case. Advertising by affiliated licensees. All ads must be done in the name of the broker firm as it is registered with the commission. And the qualifying broker remains accountable for content of such ads. A licensed affiliate's ad that ignores this requirement is referred to as a blind ad. So if your broker's information is not on the ad, it's a blind ad. And you have to make sure if the name of the brokerage as registered with the Real Estate Commission is ABC Realty, then ABC Realty needs to be on your advertisements. Broker firms' name and telephone number must be included on all ads and must appear in equal or greater lettering, size, prominence, and frequency than the lettering of any affiliated licensee's name and phone number. This is important because I see this also often where the agents are putting only their information. They may have, in some instances, they'll have their broker's name, but no phone number, no address, no information other than the broker's name. But you'll see their name and phone number, okay? But again, it must be equal or greater lettering size, prominence, and frequency as your name and the broker's name. It must be equal, okay? When advertising on the internet, the brokerage firm's name and telephone number must appear on every viewable page or provide a link that includes those disclosures. I'll read that again because, we're marketing now on the internet. When advertising on the internet, the brokerage firm's name and telephone number must appear on every viewable web page or provide a link that includes those disclosures. So if you're not going to have, ABC Realty's little umbrella or what have you, or little house, the house with ABC in the middle of it on every page, along with the broker's name and telephone number of your website. Whether it's a website that's provided, usually websites provided by your brokerage, they already know what the law is, so the rule is, they're going to follow that. But if you go to such companies as Wix, that's one that comes to mind, it's a web developer, Agent Image, you have to make sure that on your web page, your brokerage firm's name and telephone number appears, or provide a link that directly links them to your broker. When licensees want to advertise their own real estate, they may advertise property independent from licensee's broker, provided that the affiliate's broker has been notified in writing and has given written consent. So when you're advertising your own property, your broker, everything you do, you have to notify your broker. That's, I consider that a CYA, okay? Everything that you do to hold your license longer than 5 minutes, everything that you do, you always want to check in with your broker to make sure that you're doing everything that you need to do by the letter of the law, okay? And that includes your own real property. Ads written by a licensee who is always acting as a principal in the transaction must identify the writer of the ad as a real estate licensee. Failure to do so may sometimes result in such advertisement also referenced as a blind ad. Disclosure of the licensee's status in ads should include one of the following two legends. Seller holds a real estate license, Georgia real estate license number, whatever it is, and you insert your license number. So you need to disclose that your real estate license or the real estate license. I've seen licensed agent holds interest, or I've seen where it does say Georgia real estate license number. So you would need to disclose your license status, okay? Discriminatory advertising. Content of any real property ad must be confined to information relevant to the property itself and may not indicate any preference or limitation to any protected class or minority group. So you can't discriminate in advertisements nor anything else when it comes to real estate. You want to be careful of not limiting your ads to a certain group that's a part of the protected class.